Everyone, this is Dave Stauss. I'm a data privacy partner at Hodge Blackwell. I'd like to welcome you to our on-demand webinar. In this webinar, we will discuss the CCPA's draft regulations with respect to updates to the existing regulations. To give you some background, this latest round of CCPA rulemaking initiated by the California Privacy Protection Agency, it covers 5 topics. There are revisions to the existing regulations, which we're going to discuss in this webinar, and then there's 4 other new areas. The plan is to do webinars on the first 4 topics that you see here. We've already done a webinar on the second one, automated decision-making technology. You can find that on our blog, bitebacklaw.com. And during that webinar, we also provided an overview of the rulemaking process. So if you want some more details on like timeframes and sort of expected timeframes for when we could see these rules get finalized, I'd encourage you to take a look at that first webinar. As I said in that first webinar, keep in mind that these are draft regulations. So the goal with these webinars really is to provide a high-level summary of what's in the regulations for each of these topics. Here, revisions to the existing regulations. And we're trying to keep these webinars to 20 minutes or less so they're easily digestible. We're not trying to do a detailed analysis of the regulations. It's just when it makes sense right now, given that these are just drafts, they're likely to change. Based on comments at the board meeting, they are certainly, we expect that we'll see changes to these regulations. So we're just trying to give you an understanding of what's going on, and the detailed analysis can wait until the final regulations. And again, especially with this one too, with these revisions to the existing regulations, we're not going to go into every single change in draft regulations. We've used some editorial discretion to hit the high-level summary and to hit the bigger points. Okay, as a big lead up to get into digging into the actual substance of the changes. So again, just to kind of level set here, give you some background. We have existing CCPA regulations today, right? So what we're basically talking about is the agencies going into those existing CCPA regulations and they're making changes. They are also adding new subjects. They're adding cybersecurity audits, they're adding risk assessments, they're adding automated decision-making technology. What we're going to talk about today are the changes to what we have today and the modifications that they're looking to make, they're proposing to make, subject to comment periods, etc. So first thing we want to kind of draw out here is this. It's a slight change, but potentially significant, and here to the definition of non-business. As you know, the CCPA covers businesses. We're very familiar with the definition of businesses, and the definition of a business excludes nonprofits, right? The regulations in turn have a definition of non-business, and that definition includes a reference to nonprofits. That what they're changing here is, or proposing to change, is to change the phrase, add the phrase many nonprofits to the definition of non-business. The takeaway here is that there could be some nonprofits that could be subject to the CCPA. And the initial statement of reasons, just to explain, the initial statement of reasons is a document that accompanies the draft regulations, and it explains the agency's thinking as to the changes. So the initial statement of reasons explains that nonprofits that are controlled by a business that shares common branding and personal information could be subject to the CCPA. So that's the thought process there. Okay. Moving on, the regulations state that the agency has authority. I should say not the regulations, the statute, the CCPA itself says that one of the areas in which the agency has authority is to expand the definition of sensitive personal information. And here what they are proposing is to add children under 16 years of age when there's actual knowledge on behalf of the business, that they know they have actual knowledge that the consumer is under 16 years of age. The CCPA currently states that the business cannot sell or share personal information of consumers if the business has actual knowledge that the consumer is less than 16 years of age, and the business needs parental consent for consumers below 13, obviously consistent with COPPA, and then parent guardian consent for consumers between 13 and 15 years of age. Adding the age range to the definition of sensitive personal information would mean that businesses would need to limit their processing activities to certain activities or provide the right to limit the use of sensitive personal information. Keep in mind also that businesses need to use such data to infer characteristics. That's what triggers the right to limit use. It's also worth noting that the governor vetoed a bill this past legislative session, AB 1949. That bill would have raised the age to under 18, among other things. And also worth keeping in mind that the legislature passed SB 1223, 1223, that added neural data to the definition of sensitive personal information. That's actually not, that addition of neural data is actually not reflected in the current draft regulations, and I'm sure it's going to be added in the next version of the text. So anyway, here looking to expand the definition of sensitive personal information to with respect to children. Okay. The draft regulations also make some modifications to the request to know provisions. They add shared and sharing in a few sections to align the regulations with the statute. Keep in mind that the CPRA amendments to the CCPA added a new definition of sharing, so this is the regulations being updated for that. The draft regulations also seek to resolve a longstanding issue that I've personally had with the regulations, which is that today they state that businesses can make disclosures to third parties for business purposes, but that's just not accurate, because businesses make disclosures to service providers or contractors for business purposes. They do not make disclosures to third parties for business purposes. So it seeks to clean that up and resolve that issue in a number of different places within the regulations today, one being the request to know, also the privacy policy provisions were also updated to make this fix. Okay. The sections on consent as well, they're also seeking to actually add, in addition to the right to withdraw consent. They've explained this in the initial statement of reasons, in part by saying that is being proposed to align California with the Colorado regulations. In fact, the reality is that Connecticut was the first state to add the right to revoke consent in the Connecticut Data Privacy Act. Colorado followed later and added this right to withdraw consent through its rules, and it was done to align Colorado and update Colorado with respect to what happened in Connecticut. The draft rules also make revisions to Regulation 7004, which deals with obtaining consumer consent. Draft rules stated that business can have a yes button that is larger in size or more eye-catching, cannot have a yes button that is larger in size or more eye-catching. They also now state that the option to participate in financial incentives cannot be selected by default. So again, some tweaking here with these consent provisions in the existing regulations. Okay. We also see the draft regulations providing more examples dealing with user interfaces. First, they revise existing language that says that on/off toggles may be confusing if they do not provide further clarifying language. The draft regulations now state let me back up here. The existing language in the regulations says that it may be confusing if they do not provide it. The draft regulations state that they are confusing if they don't provide additional clarification. So you can see that with those red lines, deleting may be to are, and deleting and may require to if they do not include further clarifying language. We've just taken that from the draft regulations. I think the issue that they're trying to get at here are things like cookie consent banners, where it's difficult for a user to understand if moving a toggle means they're turning off cookies or turning on cookies. So those types of like dark patterns is what we consider those to be. The pop-up language is new to the draft regulation. It provides that closing or navigating away from a pop-up window that requests consent does not equal consent. So again, if you are thinking about a cookie consent banner or pop-ups, oftentimes these banners will disappear if you continue to navigate the site, right? Or they will have an X button in the top right-hand corner of them. And basically what the draft regulations are saying is that those actions of continuing to navigate or clicking a banner do not equal consent, and I should clarify consent for purposes of the CCPA, right? There are other laws out there that these actions may or may not constitute consent, but this is CCPA purposes consent. Yeah, so the initial statement of reasons says that these changes are done to align the CCPA regulations with the Colorado rules. And I would also keep in mind that we saw the New York Attorney General's office issue guidance over the summer on these types of user interfaces, and you can find that article, an article on that guidance on Bite Back, our blog. Okay, moving on. The agency also has proposed adding some additional language to the regulation 7004 subsection A5. This section requires businesses to not create unnecessary burden or friction when a consumer submits a request. And so here the agency is proposing to add language that states that requiring consumers to fill out multiple or duplicative forms can be a CCPA violation. The agency also has proposed language saying that individuals who handle requests through a toll-free telephone number must know how to process CCPA requests. The alternative opt-out link. So the regulations also propose a change to the alternative opt-out link. Specifically, what they are proposing is to allow businesses to adjust the color of the icon, that is that check and X icon that you see below the text there. But that's only in instances to ensure that the icon is conspicuous. So it seems that this is less than helpful to businesses. Most businesses seem to want to modify the color of the icon so it matches the website's color scheme, and that's not what the regulations are getting at here. It's to ensure visibility, not to match the color scheme of the website. So anyway, request to access. So the draft regulations also seek to add a new requirement for businesses that maintain personal information for consumers for more than 12 months. So some background is kind of necessary here. The statute says that businesses need to provide information for prior 12 months. The CCPA statute, that is. However, the CCPA in its statute goes on to state that a consumer can request information beyond the 12-month period, and the business needs to provide that information unless doing so, quote, proves impossible or would involve a disproportionate effort. So this requirement to provide information for beyond the 12-month period applies only for personal information collected after January 1st, 2022. The issue that the draft regulations are trying to solve is that while consumers have the right to request information going back for more than 12 months, dating back to January 1st, 2022, there's nothing in the regulation that currently requires businesses to tell consumers this. So the initial statement of reasons said, quote, that this proposed regulation is necessary because consumers may not know that upon request they are entitled to obtain this information. The draft regulation, you can see it there in the second box. It includes a couple examples of how businesses could provide this request, including providing a date range or an option to request all personal information that the business collected. I think a byproduct of this change would be if it came to actually find its way into the final regulations, would be to further encourage companies to delete personal information that's older than 12 months. All right, moving on. So the draft regulations also include a new requirement when a business denies a consumer request. Specifically, the business would have to tell the consumer that they can file a complaint with the agency and the Attorney General, and also provide links to the complaint forms that are offered by both of those organizations. So this is similar requirement as found in the Colorado Privacy Act rules, and that requirement stems from statutory language that's in the Colorado Privacy Act and other Washington Privacy Act variants. This again then is another example of the CCPA regulations looking to integrate requirements from other state privacy laws. It's also worth noting, though, I think, worth noting that at the IAPP's PSR conference earlier this year, the agency representatives on the panel said that the agency reviews every complaint that comes in. So this type of addition, should it find its way into the final rules, could certainly increase regulatory scrutiny of denying requests. Okay, opt-out preference signals. This could be a change that could cause some practical headaches. For background, again, some useful background, I hope the CCPA regulations require businesses to recognize today to recognize the global privacy control signal if you are using tracking technologies and you are not recognizing the global privacy control signal. You should. So that's today, requirement today. This is typically done through a consent management platform, like a OneTrust type consent management platform. So as it stands now, businesses have the option of displaying that they have recognized the signal. It's optional. And you can see that here where it says may display whether it has processed the opt-out preference signal. The draft regulations seek to make that mandatory, change may to must. And so businesses would need to say that they are recognizing the signal. This is something the agency wanted to do when they promulgated the regulations initially, but they eventually decided to make it permissive, not mandatory. Back in the day, they had said that they had made certain changes in order to get the regulations across the finish line and get them done. Now they're doubling back in a number of areas and coming back to things that they wanted to do previously, and this is one of those things. The initial statement of reasons states that this change is, quote, necessary to avoid confusion for consumers about their opt-out status while using a business's website or online services. All right, 2 more slides. The draft regulations are also going to seek to add this new example of how businesses process opt-out of sale and share requests for programmatic advertising technology on their websites. Basically, the example says that businesses cannot wait 15 days to process those requests and instead have to do it immediately because it is feasible to do it that way. Finally, I did not go into it in this webinar, but it's worth noting that many of the existing regulations are also revised to add references to the new regulations on automated decision-making technology and the cybersecurity audit. So in other words, if you read through the updates to the existing regulations, you're going to find references like in the privacy policy provisions and other places to disclosing automated decision-making technology, and you're going to find references to cybersecurity audits as well. So keep that in mind as well. And we're doing, like I said, we're doing on-demand webinars on each of those topics as well. Okay, I'd like to thank you for attending this webinar. Please keep an eye out for 2 more webinars that we are rolling out on those additional topics. And also we have a webinar already existing on automated decision-making technology. You can find that on Byteback or also on our YouTube channel. Thanks again.